Hey, everybody. Welcome back to the weekly immigration news recap, where we break down what changed in U.S. immigration this week and what signals came from the Trump administration that could impact your immigration situation if you're a foreign national, or your client strategy if you're an immigration practitioner. Today is Thursday, August 28th. It's about 1:26 p.m. Eastern Standard Time, and this episode is going to be released tomorrow morning on Friday, the 29th. To cover all the immigration news with me this week, I'm really lucky to be joined by Loren Locke, owner and managing attorney at Locke Immigration Law. We'll get into your background and your practice in just a minute, but first, can you tell everyone where you're joining us from and how your summer's going so far? End of summer.
Yes, thanks so much for having me today, Finn. Joining you from Atlanta, where I have my own practice that I opened about 2.5 years ago after working in large law firms doing business immigration for about a dozen years. Prior to that, I was a Foreign Service officer with the U.S. State Department. Summer is winding down in Atlanta. The weather's actually cooling off and everyone's been back to school. So it's back to work, and it's been a really busy week in the immigration world. So we've got a lot to discuss.
So I want to talk a little bit more about your background in the Foreign Service and then the types of clients that you're currently supporting in your practice now. So maybe let's start with the latter, and then we can dig back into your Foreign Service experience.
Okay, so I am a business immigration attorney. I explain that to people. I help companies move around workers. So traditionally, employment-based immigration is lawyers working directly for companies, helping them with their entire portfolio of all the foreign nationals that they have and all the needs that they have. So there'll be people who get hired and they're on F-1 OPT, and then they transition to H-1B, and then they have a green card process. There are international transfers when companies want to bring existing workers from foreign offices into the U.S. And there's a whole smorgasbord of visa options that are less common than H-1B. So that has traditionally been most of my practice. I would say, though, that since I have gone out on my own, I do have a lot more direct representation of foreign nationals trying to get green cards on their own. That's been a really booming part of the practice lately because there is such a high demand, as there have been some wrinkles and problems with people just going through the traditional do a labor certification, do the I-140 and wait for a priority date. Um, some companies have backed out of that. There have been layoffs that have disrupted it for a lot of companies. There's been that chilling effect from the Department of Justice going after some of the big players in labor certifications in the last couple of years. There have been a lot of reasons. And I would say also just the H-1B wait is really long. So a lot of people are thinking, oh, I trusted that my company would just get this taken care of and I'd focus on my job and they'd focus on my immigration, but maybe I also need to focus on my immigration. So I would say there's been huge demand for that. And it's been a growing part of mine and many other people's practices.
Yeah, it definitely seems like a trend that's emerged over the last maybe 3 or 4 years that didn't
Yeah.
necessarily exist before, where a lot of individual foreign nationals are taking more ownership over their immigration journey, um, as opposed to relying on their employer to basically like own the process for them from start to finish, which, in 2013 used to be a pretty safe bet and a fairly streamlined bet for most individual foreign nationals, but in 2025, maybe not so much. So talk a little bit about your time in the Foreign Service. What were you doing? Where were you based? And how does that sort of how has that experience informed what you do now as an immigration attorney?
So it's really the reason I probably became an immigration attorney. I had gone to law school, but straight out of law school, my first position was joining the Foreign Service. So it was like at that time a really long process to get in, and you never really know if it's going to happen until bam, it happens, and it's like a take it or leave it opportunity. So I took it, and I was posted in a border city in Mexico. I was doing non-immigrant visas, so that was really my introduction. I had done some immigration law study in law school and research, but this was okay. Now I got to do 100 visas a day, and the border cities of Mexico traditionally have had a huge number of third country national visa applicants. So you're just dealing with such an interesting and wide variety of cases. So it's really it's like trial by fire to learn all this stuff and go in and make these snap decisions that are so impactful on people's lives, based on your 30 days of training and your 2 minutes paying attention to their case. So it was a really challenging, super interesting job that I think has really played into how I can advise clients now and like just having some insight into what is going on the adjudicator's end and the kind of pressure and priorities that they have, which can be so different than what the applicants think. What an applicant thinks they need to say and prove and show is not the same as what the adjudicator needs to hear and see to make a decision. So it's been a really important part of it's really informed my whole legal practice, I would say, in all the years since then.
Sure. And I also imagine you got very comfortable with understanding what it's like to deal with changes from the top, policy shifts, process shifts from the top for those adjudicators when you're at
Oh,
the Foreign
yes.
Service. And
Yes,
obviously,
definitely. I don't know if it was changing as rapidly then as it is now, but certainly, new bosses come in and want to put their stamp on it, and we're definitely seeing that today.
yeah. And we got plenty of news to cover on that front. So we'll get into it in just a minute. But first, just a little bit of housekeeping. Lauren and I will spend the next 40 minutes or so breaking down the most important developments that happened this week in the immigration news. We're going to primarily focus on what's happening inside of the Trump administration, at USCIS and the Department of State, also some other agencies as well. And in some cases, we might just recap the headline, but in others, we'll go a bit deeper and try to provide a bit more context around why that news story could be a signal or a real factor that will impact the work of immigration practitioners in the coming weeks and months, and especially the stories where Lauren has a unique understanding of what's going on there from her experience. We're also going to talk a little bit about a quiet but pretty significant update from the immigration courts today, but we're going to skip over Congress again because I've said this for the last several weeks now, they're not in session, but they will be back in session on September 5th. So we'll see if there's any major movement on immigration legislation in our episode next week. So, Lauren, you ready to jump in and get started?
Yes, I am.
Perfect. I'll go ahead and share my screen and we'll look at our first story. So, the first story we're going to cover this week is a really big one. And we're not going to talk through all of it, but we're going to pull out some key points and share sort of our initial reaction here. But Andrew Craybaum from Bloomberg Law, for those of you who are watching, can see on the screen here his article about the Trump administration proposing limiting foreign students to a 4-year stay. So this article is based around a new rule that was proposed by the Trump administration, where the text of the rule was released yesterday, that would effectively end a long-standing policy that allows F-1 students, J-1 exchange visitors, and a few other visa holders as well, to have their visa be valid for as long as their program is, without them needing to require extensions of status with USCIS. This rule's still in the very early stages. It'll go to what's called the public comment process in the coming weeks here. And then a final rule will be issued, and it may or may not go into effect. There's a lot up in the air in terms of potential litigation around it. But we'll break down sort of the different components of this proposed rule in a minute. But Lauren, I guess my first question for you is just what's your overall reaction to the release of this rule? We sort of knew it was coming, but we got to get our first glimpse at the text and all the different provisions in it yesterday.
Yeah, I think this has been a long time coming, and it fits with a lot of the other changes that have been proposed and have been being implemented that are making it a lot harder and a lot less desirable to be an international student in the United States. I think it seems sensible, like, oh, well, why would you need longer than a 4-year stay? That's how long it takes to get a bachelor's degree. But there have already been so many rules around being a student maintaining lawful status, and it is already handled by the partnership that the State Department has with the individual universities that are hosting these students. So USCIS hasn't had a layer on top where they're also second guessing whether the student is taking too long. It just seems like another layer of complexity that is going to make it a lot easier for students to stumble and fall off the path for things that, you know, are so common for students, taking 9 semesters to graduate, that's common, and it's not always your fault. What if the class you needed got canceled and got moved to the next semester? What if you got sick and you dropped your course load? There's so many things that have been considered like this is below what the level that like the State Department should personally have to think about. And it's completely the same with all the J-1 visas. There is that intermediary, so it's not the U.S. government that has to think about, well, is it, should we allow him to change his major? Um, that's been something that's handled between the student and their DSO in their international student office, and the government doesn't need to weigh in or decide if it's appropriate or evaluate that student's individual circumstances. Um, and now they want to. So it's going to make it, um, it's going to cause a lot more students to violate their status, fall out of status, and have a problem finishing their degree and transitioning from their student status into another status such as H-1B. And I kind of wonder, is that the reason for it? You know,
Yeah, I think we'll get into that in a minute. First, I sort of want to draw back on your experience as a foreign service officer here too. Obviously, the proposed rule really only outlines how things will change at USCIS and how USCIS adjudicates extensions of status for these for these F and J visa holders, of which there are hundreds of thousands, if not millions in total. Um, but when you were a consular officer, can you maybe talk through like let's just stick with F-1 students, like the types of documents that an F-1 student applying for their visa to consulate abroad needs to bring to that interview in order to get their visa approved? Like, and then this is more speculative, but like, what do you think would change under this rule? If somebody comes and they have a 4-year admission to Georgetown University, right? Like most foreign students do, is that going to change how the adjudication officer approaches this at all?
I don't think it should change things right off the bat. So when a prospective international student comes to get their F-1 visa, they've got the I-20 that is already endorsed by their school. So that is how the consular officer has some comfort, like someone's looked at this. It's not up to me to decide if this 18-year-old got admitted to this college and it, can reasonably pursue this course of study and can reasonably pay for it. That's all kind of decided and set forth. Like this is when they're going, this is the school, this is the major, this is how much it costs and where they got the money from. It's all summarized there on the I-20 and it's already signed off by a designated representative from their school, and their school has already been authorized to host international students. So you already know that there's so much that has already been taken care of before they're standing there. So the consular officer has to think, okay, is there a reason I shouldn't give this student the visa? Is there some ineligibility? Does he have a criminal history or past immigration violations, or he said something that makes me doubt that this is a real plan? But otherwise, they've been really straightforward and had a really high approval rate because so much of the work, the student was admitted to the university. The student already has been working with the international student office. It's already been laid out and someone else already decided the finances work, the admission's legit. Like there's not that much left to do by the point of the visa interview. That is really changing in 2025. Um,
Yeah, right. Right.
so
Yeah. There's a lot of other changes that are making it more difficult for prospective foreign students to obtain their F-1 visa that
yeah.
we've covered in past podcast episodes, and I'm sure you've been covering very closely. But for the purposes of this rule, this is really impacting. There's not a lot of change. Like it sounds like you're saying, there's not a lot of change in terms of getting the visa to start school, but once you're ending your your original program set for your school, right, which might be 4 years, but maybe it needs to be extended, maybe it's shortened, etc. That's where this rule sort of comes in and changes the game a little bit.
Yeah, I think this is going to affect the transitions because it has been It has been really straightforward. You get the 5-year visa, you go to school. So even if you're going for a master's, it shouldn't take 5 years. It usually doesn't. But
Mhm.
but if you want to change programs, if you want to change schools, um, if you want to stay on and do OPT and STEM OPT, that same visa covers you that whole time. You don't have to face and you don't ever have to worry that your I-94 is going to run out because as long as you're doing what you're supposed to be doing, your school's keeping tabs on you and they're endorsing that you're doing it, it's in the CVIS program, then you're fine. And you don't have to worry that, oh, now your driver's license is going to be expired because it was tied to your I-94. Or you have to ask for permission again to keep staying and then wait for USCIS to throw up whatever roadblocks and delays to approve you to to keep being a student.
Yeah, exactly. One thing that I wanted to zoom in on a little bit and get your reaction to, and I'm going to share the actual text of the proposed rule now. And at the very beginning, it sort of cited that in 1978, when duration of status was first introduced, I had no idea that it was that old. Uh,
Hmm.
but when it was introduced, they cite that there were really only there weren't that many foreign students who were coming to the US. But in 2023, the number of individuals who were admitted into the US in F status rose to about 1.6 million. And basically, the contention here in the rule is that the sheer number of foreign students and of exchange visitors coming on J visas is too much for the government, DHS, State Department, to adequately vet all of these individuals, right? Does that, you were at the State Department not too long ago, right? These numbers weren't that different in 2010, for example. Was that is that something that you experienced where um, the increase over time in the number of students applying for visas and coming here was something that the government wasn't able to handle?
No, it's kind of funny to compare 1978 to 2025. They're different in a lot of ways. Adjudicating a visa, even up till 9/11, was very different than it is now. And computers have really changed a lot of it. Instant communication, the ability to search databases easily. There are all kinds of security checks going on now that did not exist in 1978 or even in 2001. They still didn't exist. Um, we have a much bigger world population than we had in 1978. We have a much bigger, more robust uh, infrastructure to give out visas. We have seen, in past administrations it's been important to have international students for a lot of reasons, and it's been considered pretty positive that these students come, they bring their diversity, they bring their cash, they are taking seats in these programs that are important, that are they're doing research, whatever they're doing. Do we want them to be doing that or do we not? If we want to reduce the number of international students, that is a totally different discussion, I think. And I don't think we want to reduce it by, deterring people by making it too much bureaucracy. I would think, maybe we only want our best universities to host. Maybe we only want certain programs. Maybe we want to put cap on it like they do with H-1B. Maybe they want to coordinate it so that, the H-1B numbers suffice for the number of international graduates coming out of our schools. Whatever they want, I don't think you just want to say, hey, let's just make it really tedious and unpredictable and have a lot of people have to quit their program in the middle because, the paperwork makes them stumble. I don't think that is a real direct way to go at the supposed problem of, there's too many people coming to the US and it's hard to keep track of.
Yeah, I mean, the general trajectory of the Trump administration's policies thus far have been, I think it's fair to say, add additional red tape to the process of obtaining a student visa and other visa types, but student visas in particular. And that's been covered pretty substantially in the news. This week, there was a little bit of a debate sparked up. I don't know if you saw it. I didn't include it on the news docket. But President Trump, it's sort of an offhanded comment, mentioned that in negotiations with Xi Jinping from China, he essentially offered him 600,000 visas for Chinese students to come to the U.S.,
Yeah.
which which
Uh,
Look, most of the time, I'm actually one of the few people who takes those offhanded comments by Trump more seriously because somebody put that number in his head, which means there was a policy discussion at some point around that number. But that one, with everything else at play, I sort of just dismissed and didn't include it. I don't know if you have any thoughts on sort of the ping pong and rhetoric around how the Trump administration feels about international students in the U.S.
It is so interesting to see international students treated like, little pawns for trading. I think that there's a lot more going on. When when visa approval periods are shortened, that's not because, an individual did anything. It's like this tit for tat with foreign countries when we set our reciprocity for all the different types of visas. It's kind of, I don't even know how you'd go about saying, okay, you can have 600,000 visas because already there's no limit on how many student visas any country can have. It's not like green cards where we put, everybody gets a piece of the pie and they can't exceed
Right.
their piece. So I don't really know what it means to say Chinese people can have 600,000 visas. I would love to know, the background discussion that led to that comment because um, I guess I'm happy that, there's some willingness, some understanding of the value, but I also just don't like the bargaining chip feel of it to say, oh, you could have 600,000 or maybe you can have some different number. And this is real people's individual lives um, that haven't previously been quantified and traded around in that way so explicitly.
Yeah. The last thing I want to talk about in this rule, and then if there's any other points that you want to hit on before we go to the next topic, we can. But is really expanding more on that transition from graduating as an F1 student from the university that you're attending in the U.S. to what most F1 students do if they stay, which in the U.S. after graduation, which most do, is they get their 1 year OPT work authorization. And now, under this new proposed rule, because you're only able to have a 4 year visa um, to come for your degree, you're going to need to, in addition to applying for your OPT work authorization, you're going to need to apply for an extension of status application with USCIS. USCIS did run an analysis and estimated how many new extension of status applications that they would have to process as a result of this rule change, right? And they broke it down for each of the different visa types that are being impacted by this rule. But for F1 students, it would be about 205,000 new extension of status applications filed per year. Loren, unless you think otherwise, my best guess is that that 205,000 is the majority of it is going to be students who are transitioning from graduating from their degree into OPT, just because that's sort of the transition period that's most being impacted by this rule. And then on the cost front, sorry, let me go to here. On the cost front, USCIS estimates that the impact of this rule will cost the foreign nationals, the corporations who are hiring foreign nationals on OPT, and universities about $390 million a year going forward. And they break that down a little bit further into the document, but we won't go into it for now. So, Loren, I guess what's your reaction to that? You work with employers. You know that a lot of employers hire a lot of F1 OPT students because a lot of big tech employers or manufacturing employers hire students straight out of college, and foreign students are sometimes included in that pool. Um, in the past, it's been fairly easy for corporations to hire foreign students because unlike the H-1B, they don't have to go through the employer sponsored petition process, right?
Hmm.
All F1 students are able to get OPT after they graduate, and if you have a STEM degree, you can get 2 extra years on STEM OPT. How do you think this change, I mean, impacts the landscape for corporate immigration programs and for the graduates, the foreign graduates that they're hiring?
I think it makes it even tougher for foreign graduates to actually land a job, even OPT, with a U.S. employer. I I can't imagine a lot of U.S. employers are going to be excited to pay these fees, and I don't think they will. I think it's going to be a burden mostly borne by the international students and their families. But the timelines are so tight from graduating to starting your job. If you don't start your OPT job soon enough, then you will lose out and you do not get to do OPT. So I think a lot of people are just going to be shoved out of the process because they don't have everything lined up in time, because it's going to be really hard to do, because you're going to have your EAD, you're going to have your extension, you're going to have your job. And employers that are paying attention are getting more and more nervous um, about employing people with OPT. And then, there's this fear that's OPT and maybe STEM OPT, maybe just STEM OPT will go away. And a lot of employers are aware that the H-1B lottery has already been tough and may get a lot harder in the next cycle. So I think that the international students who do graduate are going to have a much harder time transitioning into the workforce. And I think that's kind of the point, right, of this rule.
Yeah,
Um,
I posted about it on LinkedIn again yesterday, and I'll share that video in the description so folks can go and watch it. But Joseph Edlow, the USCIS director, in his Senate confirmation hearing back in May, was asked by a senator about the OPT program, and he essentially indicated that it was his. He was going to aim to effectively end the OPT program, was his response. This rule obviously wouldn't do that, but for some of the reasons that you just laid out there, it is going to make it a lot more difficult for students to get OPT, get their job, and it's going to make it maybe a different consideration for employers to hire OPT employees, whereas before it was sort of a no brainer.
There've always been a lot of mixed messages about what is the point of having international students in our universities? Why would they want to come? What are the universities getting out of it? What is the US economy getting out of it? What are the individuals that come here to study getting out of it? And we have these inconsistent messages. It's like, okay, well, H-1B, we're going to hold 20,000 seats in the cap just for people who graduated from our own master's programs or higher. But also F-1, you're not even supposed to have immigrant intent. So you're supposed to, be this 18-year-old that has this plan to go get your degree and then go get out of the US. But then we have the OPT and the STEM OPT that are helping you get your foot into the American labor market. Um, so I don't I don't I f right now, it seems like everything is pushing toward, like, you can come, pay for your degree and get it and leave, but we don't want you here. We don't want you to participate in our labor market. But we haven't actually changed the rules yet, about the H-1B. We haven't changed their ability to change to another status. A lot of employers like to hire, international graduates who come out of American institutions. Um and I think that the impact on universities, if our international student system falls apart or becomes less desirable, it's going to be an enormous impact on their finances and operations for some of these schools.
Yeah, I mean, that's the whole other component of it that, again, President Trump sort of referenced in his offhand comment about how a lot of smaller universities, a substantial portion of their student base are foreign students. I mean, I went to George Washington University. At least 30 or 40% of the entire student body were foreign students. And all of those foreign students, as you well know, pay full tuition. They're not able to get financial aid from the school, for example. And so that is a huge part of the economy that this rule and some of the other changes from the Trump administration could impact.
And we've just peaked in how many American kids graduate high school each year. It's only going to drop from here on
Mm.
out. Um, and that's not even including what's going on with immigrants who might be gone from the US by the time they get to college age. But the American born kids, the birth rate has dropped. The colleges are going to see a decreasing number of matriculating students from the United States. So are they going to shrink, or are they going to make up for it with international students? So basically the two choices, right?
It's a good question. I will say before we go on to our next story that I think, I spent a lot of time trying to just like understand the mindset and the priorities of the Trump administration when it comes to immigration policy. And I think a
Mhm.
lot of these programs, F-1 OPT, just the F-1 program, in general for international students to come here, like you mentioned, there's no cap on it. And this rule cites the fast increase in the number of students that have come to the US over the last 40 years, right? And as a result, there have been more graduates who are on F-1 OPT and more entries in the cap, et cetera. A lot of these programs that were designed in the 1990s or even earlier have become victims of their own success. But I think the Trump
Mhm.
administration, at its core, the folks who are in these decision making positions, they want to return these programs to their original intention, even though we no longer exist in a world where they fit, right? So that's going to cause obviously a lot of disruption for the
I,
people who are currently in the system.
there's really no going back to the 1970s for the American university system. I mean, I can't even imagine how different it was then, how rare it would be to, take a ship or a plane to come over to the US. You're not going to be, um, there just wasn't that connectivity that there is now that has made, our universities actually accessible to this certain um, elite portion of the world community. I mean, how many presidents from countries around the world went to US universities? It's a
Sure.
ton. It has been such an important part of America selling our mission, selling our vision, selling our values to the world. It's probably been an important part of why so many people around the world speak English. And as we toss all that into the trash, we need to really do some reflecting on, was it good for us? Is it good that so many people spent a semester or got a master's degree here in the US? Do we want that for people? Do we want people to have the opportunity to do these J1 exchanges? What happens when all that goes away?
Yeah.
And are we going to be better off? In what ways are we going to be better off or worse off? It's really complex, and certainly there's no just like let's pretend we're in an era before aviation and internet and um, international study abroad, because we're not.
Yeah.
The world has changed a lot.
It certainly has. Well, final note on that rule. I think the text is in the Federal Register now, which means folks can go in and submit public comment. So I'll put the link to the Federal Register, to the rule in the Federal Register, in the show notes. So if anyone feels so inclined, they can go and read the 160-page text, and they can even submit a public comment if
And
they'd
please
like.
do.
Yeah. With that, we'll go ahead on to our next story. And this is from my newsletter, which I just launched yesterday, actually. It's called the Immigration Intel Report. It's just a quick recap for folks. It's essentially going to be a spin-off of our Immigration Insiders meeting, where we have folks like Doug Rand, former senior advisor to the USCIS director, Michael Valverde, who used to run all the field offices at USCIS. We're going to recap those meetings in this newsletter, but we're also going to pull back the curtain on some of Lawfully's data that we share in those meetings. But that, because we only release the audio version, we don't actually share the graphs and the data visuals. And so I'll put the link in here if anyone wants to go subscribe. The newsletter comes out weekly. But one item from this newsletter that I want to talk with Loren about, because this is something she's very familiar with, is the decline that we've been tracking at Lawfully in approval rates for EB-1A I-140s. So for folks who are watching, you can see the chart in front of you, but for those who are just listening, I'll orate it. So EB-1A I-140s had an approval rate in March, in Q1, I should say, of 2025, so January through March, of about 72%. And that's the latest data that we have released from USCIS. USCIS's official data. In Lawfully's data set, we were tracking about the same approval rate for Q1 2025. That's January through March. We were tracking at about 71.6%. Now, we track a very substantial number of I-140s for the EB-1A category that are processing and are adjudicated by USCIS. And so we have a margin of error in our data of only about 4%. And over the last 4 months, from April all the way to July, we were tracking a pretty steady decline in approval rates for I-140s for EB-1A. And in July, it dropped all the way down to about 43% in our data. So, Loren, you work with clients on the EB-1A. I'm curious, what have you been seeing in your practice in terms of adjudication trends? Have you been seeing specific types of pushback from USCIS? What do you think is accounting, or some of the factors that might be accounting for this drop in approval rate?
So, in addition to my own cases, I see a lot of people's denials. I do a lot of consults for people who just got denied. So I have a pretty decent insight into what is going on. And we are seeing more and more and more cases where USCIS finds, oh, wow, you did satisfy 3 or 4 or 5 criteria to show your extraordinary ability. But we don't care. You're going to lose on the final merits determination. You lose. And we're seeing a lot of people get a notice of intent to deny right off the bat before a request for evidence. We're seeing a high rate of request for evidence, sometimes more than one request for evidence in a row. That said, I've still had plenty of success. I definitely think it's still worth trying. And I see why there's such demand, because I would say that a lot of people, every H-1B worker from India, for example, has motivation to do the EB-1A because the EB-2 line is too long. It's just really long. You could retire or die before you get your green card if you haven't already gotten a good priority date years in the past. More and more H-1B workers aren't even having the opportunity to even get a priority date through labor certification because a lot of big tech employers are really backing away from labor certification. So that leaves EB-1. We haven't even talked about NIW, but that's another option. There's basically two options if you're going to take ownership of your own green card process and you don't have an American spouse. Like, you're going to try to transition from a non-immigrant work authorized visa to a green card. You've got EB-1A or you've got national interest waiver. I get why so many people are trying. I think that we're seeing, this steadily dropping approval rate is obviously very concerning. I don't think it's the end of the road. I think that uh, immigration practitioners are going to have to retool. I've been retooling. I'm constantly trying to meet the moment with what is working with adjudicators today. A lot of people still file like it's 1995 and it's 1,200 pages long. Um, I don't think a lot of people in 2025 have the reading comprehension and attention to really dive into a support letter that's dozens of pages long. I just don't think they'll do it. So if you can't make a really strong case for yourself in a really appealing, digestible way, the adjudicator is not going to dig deep. They're not going to go educate themselves on your field of expertise so they can judge whether you are impressive. If you don't lay it out for them in a very appealing way, you are going to lose. Um, so I think, I hate to see a 43% approval rate, um, but still a lot of people getting through. And there's still a lot each individual person can do to maximize their own prospects of getting through. And the other thing that's nice is you actually can try more than once if you need to. So, whereas a lot of, if you're an H-1B worker, it's your employer that's handling your renewal. And if your renewal gets screwed up, you're out of status and you lose your job, you lose your home, you have to leave. It's a mess. If you try for a national interest waiver or an EB-1A and it fails, you have spent time and money and hope and dreams on it, but you haven't ruined your life. So there are a lot of people that will throw their hat in the ring and just see how it goes, hoping it will work, but not facing devastating consequences if it doesn't work.
Yeah, and one thing I'll note on this chart too is that um, during the Biden administration, I think folks got pretty um, comfortable with just consistent adjudication trends for the most part, not always, but fairly consistent adjudication trends. We looked at all the different form types in the USCIS data and our own data from the Biden administration, for the most popular employment and family-based form types. There weren't massive month over month or quarter over quarter changes in approval rates or RFE rates. But if you go back to the first Trump administration, I'll use H-1B RFEs, for example, there were
Mhm.
huge swings. I mean, there would be one month where the RFE rate for H-1Bs would be 30%, and then the next month it'd be 65. And then it would, hover around 65 for a few months, and then it would trickle all the way back down to 30%, and then maybe it would get all the way as low as 15 a few months later. And so it is likely that that's also going to be the case in this Trump administration, where we'll see more fluctuations in approval rates and RFE rates than we did before. And that's one of the reasons why we're tracking it with such granularity at Lawfully, is so that we can provide that information to folks like Lauren and to any foreign national who's seeking specific visa types.
It's so maddening, but then it's also like, what do you like, even if I say, "Okay, July was bad," like, is it gonna drop more in August? Well, it's too late for August already. Like, it makes it hard to actually plan, and I don't think if you'd been, on Trump's inauguration day, would you have said, "Oh, I should make sure I file so it's adjudicated in March because that's gonna be the high point." How would you ever have known that? Why did that happen? I don't know. Um, so usually there is some gap between deciding you want to do the EB-1 and then actually filing it and then it actually getting adjudicated. Those will probably all be in separate months. So where does this leave you looking at this data now, deciding, am I going to file this fall or am I not? Would I be better off if I file, next year? I don't know. I tend to think that if your circumstances support filing now, that it makes sense to do it now before it gets worse. I'm not looking at the horizon and saying, "Oh, I think that the Trump administration's really gonna start appreciating all of these aliens of extraordinary ability, start valuing them." Um, I I I feel it's almost more like a door slamming, like run in before it slams shut.
Yeah, and our data, I'll note too, is we're tracking cases that were completed in July. So we're
Yeah.
looking at the total number of cases that USCIS either approved or denied in July. A lot of those cases were filed months ago because our data set, our data sample, tends to skew towards cases that don't have premium processing. Maybe it was added after the fact, but our data tends to skew towards non-premium process cases. So a lot of those cases that were subject to the higher denial rate in July may have been filed months ago too, back when the approval rate was much higher. So I think that's a good point, Lauren.
I
Like,
mean, they could be a year old if they were filed with regular processing and then there was an RFE, took a couple months to answer that, another few months processing. Yeah, so it would have been impossible, I think, to game. Like the people that got denied last month probably mostly filed maybe even before Trump was reelected.
yep, yeah, yep. And the reason why we release this data sooner is because, for example, the approval rate for July, the official USCIS numbers won't be published until December 30th. So knowing these trends now and knowing them in real time was at least more helpful than having to wait 6 months to find out what was happening 6 months before. Um,
Yeah, I see a ton of value in having this, and I think it can also help set expectations. 43 is not nothing. There are plenty of processes, where your chance of success would be less than 43%. And a lot of people are going to be willing to take that risk because the upside is just super valuable to them. If this can get you out of a line for EB2 that will last until your natural death, like, yeah, go ahead and try 43%. If it doesn't work, you could try again. You could, I wish it were higher, but I still think this is a an excellent opportunity for a lot of people. There's still
yeah,
gonna be a lot of people that are succeeding.
yeah. Well, we'll keep tracking and reporting on updates on a month by month basis. But Lauren, any other final thoughts on this story or just EB-1A trends in general before we go on to the next one?
I would say on EB1 trends, I really would if I could tell one thing to all people that are planning to self-file, get away from a box checking mentality where it's like, well, they have to prove me because I have 6 criteria and I have 3 things in each criteria. They don't care. You have to have a compelling story. It has to make sense and it has to touch the adjudicator's heart. Like they have to care and root for you. They're not going to root for you because you gave them 1,000 pages of paperwork that they aren't going to even look at. you have such a short opportunity to grab their attention and persuade them. And you need to go in with your best shot, which is so much more about the overall narrative than it is like, look how many criteria I have. I like to focus on original contributions as the first and foremost criterion for basically every case I file, because if you aren't convincing the adjudicator that your contributions are original and significant, then you're not going to win no matter how many criteria you have. I've never seen a case where original contributions uh, was not satisfied, but the person still won.
Yeah, I think that's very, very wise advice. So the last story I want to talk about today is the Trump administration over the last month has been speaking a lot about H-1B visas. And Laura, I know H-1Bs are part of your practice and have been throughout your career. And I don't think I've ever heard an administration comment so much on their desire to reform or in some cases eliminate an entire program, immigration program like the H-1B. So I just want to play for about 2 minutes here for those watching and listening, a compilation of a few Trump administration officials talking about the H-1B, and then Lauren, I'll go to you for your reaction on sort of what you think this means for the entire employment-based immigration system going forward.
I'm involved in changing the H-1B program, right? We're going to change
Well,
that
that's a scam.
program because that's
Yeah.
terrible, right? We're going to change the green card. You know, we give green cards. The average American makes $75,000 a year, and the average green card recipient, $66,000. So we're taking the bottom quartile.
right.
Like, why are we doing that? That's why Donald Trump is going to change it. That's the gold card that's coming. And that's we're going to start picking the best people coming to this country. It's
Yeah.
time for that to change.
I was frankly not even aware this was an issue until a couple of weeks ago, and I'm trying to dig into it a little bit, which is where, on the one hand, you see some Silicon Valley technology firms, especially the big firms, say that they are desperate for workers, that they can't find for workers, that they have to use, overseas visa programs to find workers, and yet at the same time, the college-educated employment rate for STEM graduates in this country seems to be declining.
Yep.
Well, wait a second. If you're not hiring American workers coming out of colleges for these jobs, then how can you say
Right.
that you have a massive shortage of these jobs? And by the way, you see some big tech companies where they'll lay off 9,000 workers and then they'll apply for a bunch of overseas visas. And I sort of wonder, that doesn't totally make sense to
The
me.
math doesn't.
We need people who are going to help continue to grow our economy and supplement the industries that that they're involved in. The problem that I'm seeing is, and this has always been a problem, you've got companies that are trying to get cheaper labor. So they're going for the highest skilled workers, paying them at the lowest wage level. And what is that doing? It's undercutting the ability of U.S. Citizens and especially students coming out of in STEM fields coming out of universities from getting these jobs. So I think H-1B is an important program, but we should make sure that that we know that the people that are being brought over at certain levels are really are commensurate with what those levels should be. So if
So, Lauren, as putting that compilation together, you start to hear some similar language from each of those Trump administration officials, right, around the need to help benefit U.S. STEM students or STEM graduates, and the concerns they have around companies hiring foreign labor on the H-1B at a lower wage. I've never seen an administration be so determined, I think, to make reforms to the H-1B program and the broader employment-based immigration system in the country. And obviously, the rule we covered in the beginning of the podcast around ending duration of status and the changes to sort of OPT for F-1 graduates. But also there's a looming new rule coming out that would change the H-1B lottery and weight it in favor of folks who have a hiring prevailing wage level as their salary. But what's your overall reaction to this? What are you hearing from your clients? that you work with around the climate for the H-1B program and some other employment-based categories?
I think that H-1B workers who are already here are hanging on tight and companies are hanging on tight to them. I think a lot of people see the writing on the wall that H-1B is getting trashed in the media. It's becoming unpopular. There's so much talk about these H-1B workers, like they're just these random overseas people plucked from their country, when really a huge portion of them come out of our own American universities. And the companies weren't actually trying to fill a seat with a foreign worker, because why would you want to? You got to deal with the government. You got to pay extra money. You got to have all these rules. They would not prefer to have an H-1B worker over a U.S. worker. But if that's who they got, because they hired them from the American pool of students and labor, um, they're doing it for a reason, and they're not just doing it to undercut U.S. workers. It also feels so quaint now to say, oh, well, we can't let them pluck H-1B workers and bring them here from overseas, to undercut U.S. workers. You know what American corporations are doing to undercut U.S. workers? They're just hiring them overseas. It's a lot cheaper and a lot easier to go set up an offshore office and just employ the people in the country where they already live than it is to handpick individuals and have to pay them an American wage and have to relocate them to the US. So I don't think we can protect, I don't think trying to protect our American workforce from the competition of H-1B workers um, is, I don't think the competition of H-1B workers is really the big thing that's threatening the U.S. workforce and our wages. It's so many other factors. It's offshoring, it's AI, it's many other things. The H-1B program is dinky. It's 85,000 new spots a year. The reason there's so many Indians in it is because they wait so long to get a green card that they could conceivably be in H-1B status until they retire. It wasn't designed to be that way. I think obviously anything can be improved in immigration. Any immigration system can be improved. The H-1B program has many aspects of it that can be improved. And we need to ask ourselves from a public policy perspective, do we want H-1B workers to have to do a labor market test like you do for a green card? Or is it fair that the employer can just say, this is who I want, this is who I'm going to hire, which is how it is now. That's what the law is. You do not have to beat out you don't have to show that there's an unavailability of a U.S. alternative worker. A lot of people think that is in the law. It's not. I can pick the H-1B worker because I recruited locally and I met her and I liked her and that's who I wanted. That was my choice as a private employer. I can do that. Do we want to take that away from U.S. companies? The other thing about maybe weighting the H-1B lottery, and this touches back on what Lutnick said about, people that earn less money have less value. Is that true? There are so many professions in the U.S. that are not the highest paid, but add a ton of value. There are many healthcare professions, education, the arts, so many things where they don't stand out for high pay, but we like them, we need them. And I kind of wonder where the data even comes from that these H-1B employment-based workers are paid less than U.S. workers. I'm wondering if it's because people wait so long from the point of their labor certification until they get a green card, and their wage was kind of frozen at whatever the prevailing wage was set at the year that they did their labor certification. So we've got people now that are getting their green cards based on a job which was planned for them in 2012. And it was set as, here's what the minimum salary has to be, 66 grand or whatever. Well, now it's 2025. I don't think that person's still earning 66 grand. If they were if their salary trajectory were actually that low, I doubt that they would have been retained in the interim 12 years by their employer that actually hung on to them that long to see through to the end of the green card process. And now we've got people entering the green card process that with our current demand and numbers, like they don't really have any prospect of ever getting a green card. And the only reason to even go through the exercise of the green card sponsorship is to secure their ability to keep their H-1B. So we've got these people that are career H-1B workers. I work with people all the time who are H-1B workers with foreign-born kids, and their kids are about to age out, and their kids might turn to be the second generation of H-1B workers. This was not how it was supposed to be. It was not designed to be some multi-generational servitude. It's like it's professional, highly qualified people, but they are kind of handcuffed because their H-1B is holding them back from full mobility in the U.S. economy. They can't go, start a business. They can't do the kind of things that you think we'd want our really bright international workers to be able to do, to be dynamic in the economy, not be small and have to stick with, the job that was planned for them in 2012 and say, oh yeah, it hasn't changed at all. It's still totally accurate. It's exactly what I'm doing. I have had no career growth at all as a third of my career passed by. We really need to do some soul search about what the H-1B is for, what experience our H-1B workers deserve, and how this all is impacting the U.S. workforce. It's very complicated and it's not well suited to like talking points on a Sunday morning news show. But I'm obviously passionate about H-1B.
No, those are all very astute points. I will say on Lutnick, he is probably the least serious of the three people I just showed in the clips, because he, back in March or April, on a podcast, talked about the launch of the Trump card, the gold card, the $5 million green card. And he said that he had already sold 10,000 of them back in March, and there's been no developments there except for a website that they've launched. So him, you're probably right. He probably got his data from one of the think tanks, Heritage or the Center for Immigration Studies. They probably did cite the data the way it's a really great point that you brought up. They probably did cite data that is, because of the backlog, old and not actually representative of the case here. But on the flip side, I do think Joseph Edlow is a really serious person in the administration, and I think he has a lot of strong opinions on reforming the H-1B program, and I think he's very determined to in his capacity as director of USCIS. So I do think that if not in the next few months, certainly in the next year or two, we're going to see probably the biggest shift in the H-1B program since the introduction of the lottery back in 2005, when demand started to outpace supply to the point where they needed to create a lottery outside of the original intention of the INA. So, well, with that, Loren, we gotta wrap up here. We just got a couple of minutes to go. I really appreciate you joining me today. But before we go, is there any final thoughts on any of the topics we discussed that you want to share? And then let folks know where they can find you, where they can get in touch with you if they're interested in getting a consultation or learning more about your practice or working with you.
Well, thanks so much for having me. It's been a really fun conversation. I would love to talk to anybody that is thinking about doing their own EB-1A or NIW if they're still into that. I take consultations for lots of individuals. I work with a lot of employers too, and I think you can find me at lockeimmigration.com. I also do a lot of videos, and if there's a topic anybody wants to hear, shoot me a message through YouTube or LinkedIn, and I'll try to add it to my list.
I'll plug Lauren's videos on LinkedIn too. I haven't watched your YouTube videos just because I'm more of a creature of LinkedIn, but I always find your LinkedIn videos very useful. I was telling Lauren before we started recording, because she throws in a lot of really interesting tidbits that I like forgot about or maybe have changed since I was an immigration paralegal about immigration law that I don't think about. So they're a great watch for those of you who are interested. But we'll put all of your Lauren's contact information in the show notes so folks can reach out. And yeah, thanks again, Lauren. I really appreciate you taking the time out of your busy day to join me, and we'll see everyone next week.
Thanks so much, Ben.